Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa, and I'm here with another webinar for you. Very exciting one. It's going to be very insightful. But before we head on with today's topic and who's going to be our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, we are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting in whichever platform you're watching. And better even, you can join us on call, and our guest is going to be here. Maybe you can ask your questions directly by joining us on this call. And the number is 425-436-6335, and the access code when they ask for it is 988-888. And once you're in, just speak. We will be able to hear you. So, thank you so much, friends, for joining us. And yes, today's topic is actually a very, very significant one, especially to the Indian community, in the United States. So, what do the 2025 US visa rules mean for Indian workers and students? That is our topic for today. And the new rules, especially with regard to H1B, are really creating curiosity among all the folks out there. And understandably, some are concerns about what lies ahead, especially for Indian workers and students. So, to help us, get insightful knowledge about this today, we are going to be joined by a distinguished guest, none other than attorney Justin Rivera, a renowned attorney from Wasden Immigration Litigation. And he has years of experience, about different complex immigration policies. And Justin is going to be here to share his valuable insights on what these changes mean and how can we prepare for them. So without further ado, please help me welcome attorney Justin Rivera from Wasden Immigration Litigation. Hi, Justin.
Hi, Nipasa. How you doing today?
I'm doing great, and this is our first webinar in 2025, so I'm very excited. I'm really wishing you a great year ahead, and yes, I'm looking forward for the session.
It's gonna be busy.
It is indeed. So maybe you could give us an overview, what can folks expect from today's session?
Yeah, well, I think, we'll all continue to delve into our crystal balls over what we can expect with this year, with the caveat that there's a little bit more information now kind of starting to trickle out. As we
Mhm.
were talking about a minute or so before we started talking, I actually just got off another call that was a pretty extensive webinar with people who actually worked in the State Department and at some of the consulates around the world during the Trump administration. So it was a very insightful opportunity to kind of learn a bit about what it was like under Trump's first administration, what things were done, and how those policies were implemented and rolled out. And they also ended by talking about the relationships that they have with people who are going to be going into the next administration, going into this iteration of the administration. And so, if you guys will humor me for about 2 minutes, I did want to kind of give you guys kind of a peek behind the curtain because this was a call that was particularly for attorneys, more so for all of us to get ready to think about challenging things through litigation or devise new strategies to kind of deal with what's going to change. So I'm going to be looking at the notes I took, which were very interesting. Biggest thing that I wanted to kind of bring back, there's been talk about the travel ban. Will there be another travel ban? It looks like yes. Pretty much, it seems, if not set in stone, then absolute, then close to, that there's going to be some new iteration of the travel ban that's released shortly after the inauguration.
Mhm.
Um, the thing that seems to be up in the air is about whether the travel ban will be a set number of countries, specifically countries like Iran, Iraq, Libya, Somalia, Sudan, Syria, Yemen, or if the Trump administration is going to ask DHS to create their own process where they would make a list of countries based on whatever prerogatives there is that they think are necessary to create this travel ban, or Muslim ban, whatever you'd like to call it. So the travel ban is going to come back. It's just basically what countries are going to be listed on it. I guess we'll have to wait and see. It was really interesting to talk to some of the consular officers who were a part of the last administration about the travel ban. the way that travel ban initially worked, it was a lot of stop and starting, meaning, it was instituted, it was stopped, it was instituted, it was stopped. There's a lot of confusion, not only at the consulates, but even at CBP. I think people, if you remember, there was, days where there were protests at airports because people were not being let into the country because of all of this confusion over who was admissible and who wasn't admissible. The consulates had the same kind of insanity. My understanding is they basically were given a short memorandum and told, hey, 72 hours, this is going into effect, and you're going to have to figure this out. One officer actually went so far as to say that it was not until 6 months into the implementation of the ban that they received a formal training, which I think anyone in any profession would have to say that's insane,
Insane.
But the fact of the matter is, we saw with this previous administration, it's a lot of just shoot first and ask questions later. We're going to go try and do X, and you figure out a way to make it work, or it gets stopped and then we move on. So kind of moving on from that, extreme vetting coming back. The Title 42 ban. The Title 42 ban was previously used during COVID at the southern border as a reason to deny entry to migrants because they were in a country that had a communicable disease. COVID obviously was the name of the game there. There is talks that they're going to attempt to use that again. What communicable disease they're going to use, I'm not exactly sure. I know bird flu is really hot right now. Lots of people scared of bird flu. Maybe that. But that looks like it's something that's going to come back as well. Things that are important for everyone and not just specific nationals. Interview backlogs. Hoping that those will be improved, but I was not very hopeful from the call that I was on that that's going to be the case. Interview waivers being removed. There was talk about what were the easiest ways to make the immigration system function worse, meaning making it more difficult for people. The removing of immigration waivers, which was something that did happen in 2017, is an easy way to make a slow system even slower. So that's a possibility as well. And the last one really hurt me, honestly, because I thought it was one of the things that the government actually had done well, the removal of the domestic visa renewal program. Sure, some people are aware that there was an implementation of a pilot program for the domestic visa renewal. It saw, tons of positive feedback from the community. And of course, that would make sense that if it was a positive thing, it'll be taken away. So those were some of the big things that were noted during the call that I thought that was really, really interesting to bring up. If you're a Russian foreign national or a Chinese foreign national, get ready for, enhanced vetting, probably an increase in the provision of 221Gs. That's going to come up as well. A really interesting facet was the idea of moving consular processing to DHS from the State Department. That argument was basically done under the guise that the State Department isn't adequate or equipped to handle consular processing, and so it should all be brought under the purview of DHS. That's really interesting because it would kind of change the game on how everything worked, because then you're looking at basically USCIS kind of holding all of the cards. And I'm not sure if that would be beneficial because it could open them up to more scrutiny from a litigation standpoint, or it would be harmful because it'd make it easier to implement more restrictive policies. That would require statutory action, though. So that's something that's not a day one sort of implementation. That's something that would have to actually be thought out. The last stuff, which was kind of the hot button issue that I think everyone was aware of during the election, is the challenge to birthright citizenship. Realistically, like I've said, and I will continue to say, I don't think this is something that could really happen. I would be surprised if it did. But what the people on the panel brought up, which I thought was interesting, was you're going to see more of an attack on this idea of birther tourism. So what birther tourism essentially is this idea that you're obtaining a visa for the reason of entering the United States to have a child in the U.S., because if the child is born in the United States, they're a U.S. citizen. So the idea is making it more of an issue at the consulate, making it more open for consular officers to deny visa applications to individuals that are pregnant unless the travel to the US is done so for medical reasons. And right away, and I don't say this to be crass, I'm being genuinely honest. Right away, I thought, and I even asked the panel, like, so do the officers then have to just make decisions on who looks pregnant or who doesn't look pregnant? Like, do they assertively ask someone if they are pregnant at the outset of every interview if that person is capable of birthing a child? Like, what
Maybe there
happens?
will be a pregnancy test too.
Maybe so, but what they actually came back and said was the consular officers, by and large, they likely don't want to do this because it's an uncomfortable thing. But you know who'd be psyched about doing it? CBP. Apparently, CBP officers seemingly have no problem with doing something like that and would be more than welcome to refuse someone entry to the United States under this guise. Now, I don't have a bad opinion of CBP, but if I could kind of give you an idea of what I deal with CBP on average, I had someone on Monday night in secondary inspection for 3.5 hours because they were related to an employer that had been found guilty of fraud. Now, this person had gone through a lawsuit in which they had won the lawsuit, their fraud claim had been removed, and they were carrying with them a copy of the document that confirmed that the fraud finding had been removed. Despite all of that, secondary inspection detainment for 3+ hours. So my opinion of them is not very favorable, in that I feel that they abuse their powers, and I feel that they definitely make an effort to target not even people of certain nationalities, but people with certain immigration history backgrounds, people that have been in the United States on F1. I think they're much more diligently going after those people than somebody who, is just coming in on an H-1B. All that being said, my understanding of all of this was the restrictions on birthright citizenship would outright be very difficult, but there's ways to get around that, and I think it's something that they're going to try to take advantage of. One person made a very interesting point, and they talked about passport applications. And I had never thought about this before until this person had brought it up. They said, what if there is an implementation of a process to determine if someone is a U.S. citizen for the purpose of obtaining a passport? Were their parents on visas when they entered the U.S.? Or something like that. That isn't necessarily stripping them of birthright citizenship, but is creating mechanisms and systems that are in turn going to make their life more difficult. That might be something that we're going to see. And so all of that, which I've taken up, 10 minutes of our hour with that, all that was to say, I just wanted to relay that information while it was fresh in my
That was,
mind.
great information, seriously, and latest information, great updates. I think we shouldn't have missed, and we are lucky that you were a part of that webinar and you have so much information to share with us today. Justin, thank you so much for that.
You're welcome.
And what
And with that
all
being
the
said,
sorry, please
sorry?
go on, carry
No. I think we had a little bit of a connectivity issue. No, I was just saying, with that being said, I know we had a couple questions we wanted to address today, so we can turn to that if
Yes,
you're ready.
yes, but from what you have shared, it really sounds like, Trump 2.0 is going to make everything more complicated, more lengthy, and a lot of scrutiny. They're going to make it difficult, and seems like there are going to be longer wait times as well. So let's see what's going to happen.
Mhm.
All right, so Justin, let's head on to our topic and some questions that we had prepared. So, my first question to you is, what changes in February 2025 Visa Bulletin will benefit Indian students and even professionals who are applying for US green cards?
So I did take a moment to look at the Visa Bulletin before the call. The February bulletin's actually already come out. Usually does around middle of the prior month anyway. There was some slight incremental growth. I think your EB-1 still sitting at Feb 1, 2022, which isn't terrible, but not the best. EB-2, you're looking at October 15, 2012. EB-3, December 15, 2012, and you have your final action dates being used right now. It's very slight, very minute incremental growth. I don't know if we're going to see much change moving forward with this year in that regard. I think there's a lot of people putting their eggs in the Doge basket, which is like quiet, which is like this idea, that there's going to be an increase in government efficiency, particularly within employment-based immigration, because obviously there's been signals from this administration that there's a favorable view of the employment-based visa programs. I know the H-1B has gotten a lot of particularly love recently, or hate if you're on the other side of it. But how that relates or doesn't relate to what we're actually going to see with the Visa Bulletin, it's kind of a wait and see. We're going to have to see what happens and if there's any sort of big changes planned. I know that there was this idea, it's just something that was floated by Trump, which get ready to go back to that, right? This guy says something, we all think, what does that mean? And then we pretend we know, and then we see what happens. But I know there was an idea floated about tying H-1B visa sponsorship to a faster green card path. Obviously, if that's possible, I'm all for it. Let's do it. But until somebody actually sits down and says, this is how we're going to do that, we're stuck with the systems that are in place presently.
Right. Right. Thank you so much, Justin, for taking that up and for the update for Indian nationals. So EB-1 looks good, and the others still just have very slight changes. Thank you for the update. And let's go on to my next question to you, Justin. And there are so many new rules coming up, U.S. visa rules. And do you think that there are new opportunities for Indian students who are looking to stay in the U.S. after graduation?
So I think for people that got, that get picked in the upcoming lottery, they really got lucky with the cap gap extension, because that's legitimately beneficial. Previously, the way cap gap worked is basically if your case was selected and you were working subject to work authorization, you had a gap. Basically, let's say your STEM OPT ended in May or something like that. If you had a timely filed H-1B change of status, you were able to continue working all the way up to 10-1 on what's called cap gap. However, that ended on 10-1. So unless your case was approved by then, you would still be able to stay in the United States, but you would lose your work authorization. The problem with that is if you're an employer and you have an employee and the employee can't work, why are you going to keep the employee? So what I thought was a very interesting and beneficial move from the DHS was they moved it to April 1st of next year. And what that does is it no longer puts pressure on the employer and the employee to rush to get that case approved by 10-1. A lot of times what you would see is the wait and see filing and regular processing around, May, June, whatever. And then a rush to upgrade to premium in September, because everyone needed that 10-1 work authorization. Now that that's not the case, I think you have two circumstances. The employee continues to have that work authorization until April if they don't want to pay the $28.05 for premium, the employer. And CIS no longer sees this mass strain where they're having to prioritize all of these cases, and instead can just allocate their workload accordingly, keep it at the same level. The other thing that I think was legitimately beneficial was the ability to move the start date. Most of the time, all the time, 10-1 was the definitive start date. First date you're eligible for H-1B, 10-1. Looks like now you have more wiggle room. You can move that back. And I think that that's great for someone who has, let's say maybe another 8 months, 10 months of STEM OPT that they want to utilize before they start that 6-year clock on H-1B. I think that's a benefit as well. So I think we've gotten some good wiggle room, things that are going to be helpful for anyone transitioning from F1 to H1B, and that should give people more opportunity. The other thing that's beneficial for graduates, they have expanded the qualification for cap-exempt employers. For anyone who lacks familiarity, cap-exempt employer is an employer that is able to sponsor an individual for H-1B without that individual having to go through the lottery. Now, it was fairly restrictive to basically like nonprofit organizations and research institutions, universities, things of that nature. They have opened the door so that individuals are now able to work with companies who are maybe placing somebody at that research institution, or maybe they're working for a company who not all of their job falls within the prism of the nonprofit or whatever service it is to be cap exempt, but what they're specifically doing does fall within that prism. It'll be interesting to kind of see how those rules are implemented and how that dynamic is shaped once those cases start to get filed and there begins to become precedent, essentially. But I think that it's beneficial, and I think it's going to hopefully open the door to more people being able to obtain H-1B sponsorship without having to go through the lottery, which does cap at 85K every year.
Yes, definitely. And these are some good news. Thank you so much for the updates, Justin, and for the detailed explanation. Thank you for taking that up. So now I have another question, and that is with regard to permanent residency. So how will the surge in visa availability this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
Um, um, can you hear me okay? Uh-oh, I think we had a connection issue.
Are you able to hear me? So my next question is on the screen already. It is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals, who are awaiting permanent residency in the US?
Yeah, I can't really see anything.
Yes, we can hear you, but Justin, can you hear me? I really hope there's some connectivity issues though at your end. Really hope that. Maybe you can just rejoin. Yes, that would be great. So, folks out there, thank you so much for joining us. In fact, you can even contact Attorney Justin Rivera. He's going to join us very, very soon, immediately, I guess. And what you can do is call him up on his number or even leave him an email. But definitely go check out Wasden Immigration Litigation in uh, LinkedIn, and his phone number is 844-592-7336, and that's where you can call him. You can even email Justin at support@wasden.law, and go visit www.wasden.law to get to know more about Justin Rivera. And Justin is back, so I think yes. Let's take up the question. I'm going to repeat, Justin.
I got it.
So
I got it.
yeah, thank you so much for just coming back. So, my question is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
So, I mean, I'm hoping that people who have that 485 filed or close to filing, they're going to at least see a timeline draw. I mean, you can even go look right now, and if you even Google it just off the top of your head, and you're like, what's the timeline for I-485 processing? You're looking at, like, I saw 8 months to 2 years. I mean, it's so ridiculous that they're not even willing to put out a defined timeline. That being said, this is where I'll kind of hope that we do see an efficiency boost as a result of the administration change. No offense to the Biden administration, but I don't think they did the best job at processing these green cards. That's just my opinion. I think you could see it. I think that there was a lot of times where these cases dragged on for a long time. And yes, people have the opportunity to work subject to an EAD. And yes, they can travel with AP. And yes, they can remain in the United States while their case is being adjudicated. But they're in the United States in a constant state or a near constant state of worry, because unless they've remained on their non-immigrant status, their future is dependent on the adjudication of the 485s. I'm hopeful that with this suggestion that there's a favorable view of employment-based immigration, that we're going to see 485 processing become more streamlined. That is a hope and not a certainty. You could even say it's a wish, but it's something that I would like to see, because I think it's an area where they could actually implement fairly quickly changes that are going to help streamline something. I think for a lot of these employment-based cases, these 485s, it should just be a quick review of immigration history. I mean, Nine times out of 10, you're not dealing with somebody that was a member of a terrorist organization, or has ties to a questionable community, or entered the country in an unauthorized status. All of these people are typically people who have come to the U.S. legally, have remained in the U.S. legally, and just want to move over to a green card holding position so that they're not constantly having to renew their H or whatever that they're on. So I'm hoping to see processing improve. From what I explained earlier, I don't know if that's going to be the case at the border. I mean, at the consulates, but maybe with USC.
Okay, okay. Thank you so much, Justin, for taking that up. And, we have a lot of Indian workers who are working or are looking for jobs in the tech and healthcare sectors. So, if you could update us with what new visa rules that are coming up this year, 2025, that they need to know about, especially with regard to green card and processing times. I think we lost Justin out there. But folks out there, thank you so much for joining us. Hi to Yash and Sneha. You can even join us on call. You can dial this number 425-436-6335, and the access code is 988-888. It'll be really great to have you here. And I think we should take a short break. Oh, and I think Justin is back actually. So, yeah, Justin, something is wrong with the internet today, but technical issues are always there, I think. Anyway, so were you able to hear what I was asking? And even if not, I'm going to repeat the question. And the question is, we have a lot of Indian workers in the healthcare and the tech sector. So, and there are new rules and updates this year, 2025. So, if you could tell us what they need to know, especially with regard to green card processing times. Are you able to hear me, Justin? Looks like some bad connection out there, but we really hope that Justin can be back, So, of control, if you can just maybe guide him a little bit.
I don't know what's happening, guys. I'm
But we're
trying.
just glad you're back somehow. Uh, are you able to hear me properly?
I can hear you, and then what keeps happening is I can hear you for like the first 15 seconds, and then you freeze up, but I still have audio, and then it says "oops" and kicks me out. Now I just closed out a bunch of windows. I did have Zoom open still, so I don't know if that was a problem.
Probably.
But I got rid of that, and I'm hoping maybe that helps. I did get a message from Xfinity, who's my internet provider, who conveniently has decided that they're going to be working, which is like the worst possible timing. See, and there we go again.
I know. But as long as you
Well,
can hear me,
I
I think we can
Yeah, I
carry on.
think, sir, control here. Sir, I think this is a bit of your connection issue. Did you try clearing your browser's cache?
no, it's
Maybe,
me. It's my end.
and maybe try to remove
Yeah,
close all the windows, and then we can pick it up from there again. Nipasa, let's go for a break.
Thank you, folks, for being patient, but stay tuned on Immigration and Jobs Talk Show because we have Attorney Justin Rivera from Wasden Immigration Litigation. And don't forget to go check out Wasden Immigration Litigation on LinkedIn as well. So, yes, let's go for a short break and don't go anywhere.
I'm back. Maybe. We'll see.
Welcome back, sir. Let's
Wait 5
continue.
seconds and then we'll know. Um,
No, let's not wait as long as it's working. So let's go for it. My next question for you, Justin, is that, we have a lot of Indian workers in the tech and healthcare sectors, and there are new rules and updates this year, 2025. So if you could tell us what they need to know, especially with regard to green card processing times.
So, not so much for tech, but I would definitely say for healthcare, I think that there should be a really close look at the new changes for cap exempt employers. I know that healthcare was definitely one of the institutions that people could attempt to utilize, especially for those hospitals that are connected to universities for cap exempt employment. So I think that with the expansion of the cap exempt rules, hopefully that gives even more opportunity for people in healthcare to find an alternative to having to go through the H-1B lottery. Tech, we're going to have to kind of see what happens with EB-2 NIW. For people that are familiar with the national interest waiver, it's one of those few ways where someone can actually self-petition for a green card. Really kick off that process. Now, that being said, I have heard through the grapevine, if it's not one thing, it's another. I have heard through the grapevine from people who specialize in EB-2 NIW that we've actually seen kind of a more stringent application of NIW over the past couple of months that could correlate to a little bit of oversaturation in the market, particularly from individuals in the tech industry. And what I mean by oversaturation is you have bad attorneys filing bad cases. And what that has done is put officers on guard, essentially, put them in a circumstance where they're saying, oh, if this is a tech case, I don't know if it qualifies by virtue of the fact that, 5,000 other people in the tech sector think that they qualify for an NIW. So I will be interested to see if there are any changes policy-wise that are made for NIW, especially for tech, when we're going into next year. Because as we've heard from Elon Musk, who seemingly sits at the right hand of the president, tech is good and we need tech immigration. So that might be something where we see a little bit better of a path for people to getting green cards in tech.
Thank you so much, Justin, for taking that up. And looks like it's going to be good for healthcare sectors, even if not for
Mhm.
tech yet. So thank you for that update. And next up, I wanted to ask, what are the key differences in the 2025 US visa rules and the previous years? And how do they specifically benefit Indian applicants?
So I think that kind of goes back to if you're already here and you're working on F1, that cap gap opportunity, the extension of cap gap, I think is going to be really positive. I think that'll be very beneficial. Moving the start date, the fluidity of the start date, I think is going to be beneficial too for everyone. But you have a lot of Indian foreign nationals, Chinese foreign nationals that are on F1s that work subject to STEM OPT. Maybe they want to push that start date back, giving them an opportunity to remain on, their NIV, their F1 status. Where I think it's going to be interesting is part of the modernization rules for the H-1B did include this idea of the bona fide job requirement. And the bona fide is allegedly a way for USCIS to adjudicate the viability of an H-1B petition based on the fact that there must be a bona fide position available for the person that's a specialty occupation.
Mhm.
And uh, how does that work against moving a start date? Or how does that work when you're filing a case in, let's say, April or May, and the start date of the H1 is October 1st? Supply documents that show that there's going to be work available on October 1st, or by virtue of the offer letter showing that you're providing the position to the person, is that enough to get you through the gate of this bona fide job offer? If you're only able to provide state orders that show that there's only work available for 6 months beyond the start date. USCIS is claiming it won't, but it's also claiming that it now has the right to request all of those documents in order to determine whether the position is a offer. So I think things are going to be wacky for the first 3 or 4 months. I think where decisions come out as officers begin to play with these new definitions. Hopefully it's all more established by the time we get to quota and people are filing those initial H-1Bs, to go through the cap. Because cap denials are always terrible because you only get so many shots at the lottery. But yeah, I think the one thing that I've taken away from this is there are things that I like that have been changed. I do not like the bona fide job requirement change. And I'm hoping that it's something that sees litigation pretty quickly after it's implemented.
Absolutely. I think, yes, we will have to have some buffer time. I mean, Trump is only joining after 5 days. So after he joins, we will hear a lot of rules coming up and more updates. So we'll just have to wait a little more and see what's coming up in 2025.
Well, and it's wild. You think about it. These new policies, the H-1B modernization, they were going into effect whether or not Trump won. They go in on 1/17.
Right.
That's on
Yes.
Friday. And then the following Monday, his administration's inaugurated. And then I'm assuming they start issuing EOs on the 21st or the 22nd. So there was already change that was going to happen regardless of who was president, whether Biden won or Trump. And now on top of that, there's a new administration. So yeah, I definitely think it's going to be a crazy first 2 months. I cannot imagine middle of January to February being fun for anyone in this.
So true. So true. And yeah, everything is planned, and we'll just have to wait what they're going to throw at us. So thank you, Justin, for that. And I have another question, and that is if you can explain, if these 2025 updates, can ease green card process for Indian nationals who have been waiting for years, all these backlogs.
So yeah, I think, like I said, you'll be seeing a wait and see for the 485 processing. I think there's mechanisms that can be put in place that can actually speed up the issuance of the green cards themselves. Whether or not they're able to actually move the bulletin up, I mean, we'll see. I think that's going to take a little bit more leg room. I think it's a lot easier to just issue policy memorandums, to USCIS to say, look, if everything looks good, just approve the case, rather than going into enhanced vetting of a process. I do think that barring any weird changes made by Stephen Miller, we should see hopefully a pretty streamlined lottery this year. I think, the beneficiary-centric lottery, it was done last year. It seemingly has worked in that it's vetted out the ability for multiple registrations to occur, which is a problem that USCIS had. So I think that hopefully we see a better lottery process with the introduction of the extended cap gap and the moving of start dates. I'm hoping that there's less stress on filing for everyone. So I'm hopeful for all of that. And I do think that that'll be beneficial. I think for Indian foreign nationals, they do typically represent a large amount of the individuals that are selected for H-1Bs. So I think these changes will specifically benefit them. So it's just, we'll have to see, but I do think that that'll help. Deference, I think, will be a big thing too. Part of the H-1B modernization is that we're supposed to be reinstituting deference. So if an extension is filed for, an H-1B visa and it's the same employer and the person's doing the same job, it's supposed to be a quick approval. You're not supposed to be rehashing old issues. So I'm hoping with that being instituted as well, we should see very quick approvals for people that are on extensions. I think the people that are hopefully that are going to be in the best circumstance are going to be people who are, they've already got their I-140s approved. They're maybe waiting for their opportunity to file their I-485, but they're just staying with the company and they're just working with that company, waiting for their time. Hopefully they get to just kind of run through the process and they're okay. And administrations are only 4 years long. So in theory, you should only have one extension. So yeah, but we'll kind of see how that goes. I think the other thing which I brought up on previous conversations is the entrepreneurial H-1B.
Yes.
This idea of being able to do H-1Bs for themselves now, as their own owner of their own company. I think that's going to be really interesting and can be really helpful for someone maybe that's an Indian foreign national who's maybe been working in the industry for a couple of years and wants to strike out on their own. And they want to take an opportunity to open their own company or organization. That being said, I reserve the statements that I've previously made, which is those are only approved, I believe, for 18 months. Lots of new businesses fail. So we're going to have to see what those extensions look like. But I'm eager to work on those. I will promise you guys this. When I get my first entrepreneurial H-1B approved, I will let you guys know about it.
Thank you so much, Justin. And I do hope like H2B is where Indian nationals are excluded. So I do hope that that doesn't happen with regard to H1B ever. So
No, no way, no way. What would they do in the tech sector if that were to happen? It'd be insane. No, no way.
all right, Justin, thank you so much. And I think we'll take up a few questions from our audience, and we have about 10 minutes from you. So let's take up some Facebook questions first. Control, if you can display them, please.
If I can stay online.
I really hope so. But yes, meanwhile, let's take up Yash's comment. And he's saying if the cap of H1B visas gets stricter, should Indian students like me consider applying under different categories like O1 or EB-2 NIW? What's the realistic timeline for these pathways? Maybe you can give a comparison.
Yeah, so I mean, like I said earlier, the NIW, I think your biggest issue is scrutiny that you're going to receive from USC. Right now, I've heard that the scrutiny is pretty high on those cases. I think you're going to have to prepare a really work with a pretty knowledgeable attorney, and hopefully you end up coming out with a positive adjudication. But like I said, NIW, I've heard from others. I don't do very many of those cases. I really try to only take them if they're surefire wins. I've heard from others who dabble more so in it that the decisions are getting wacky. They're getting weird. There's cases that seemingly look like they should be approvals that aren't getting approved, or cases that are getting requests for evidence that seem like dead ringers. The O1 is one of the most heavily scrutinized NIV applications, okay? Can you qualify for an O1? Maybe. It really depends on who you are and what you're doing. Is it easy to qualify for an O1? No. Qualify coming out of school. You have to meet the though to do so. I would tell looking at an O1, you can look online. Go to USCIS's website. It's going to tell you the requirements. Ask yourself if you fall into enough of those boxes to qualify for an O1 before you're going to move forward. Benefits of an O1 are pretty immense. You don't go through a lottery. You're not subject to a labor condition application. And your company, if it's a startup, can even pay you in equity rather than having to pay you, a high salary. So there's definite benefits to it. The caveat to that is that the O1 is going to be more difficult for you to get than an H1B. It's just going to be seen as a higher level of scrutiny. Can get them. Again, no one should file an O1 on their own. I would work with an attorney, make sure your case is set up from the outset, and move forward and see if you can get it done. I would say for anyone in the next couple of years, if you're going to be applying, if you want to do an O1 in the back of your mind and you're on F1 and you're trying to apply in the lottery, work on your resume for your O1 in tandem while you're building your H1B up. That way you're able to apply in the lottery. If you get selected, great. If not, you've got that O1 in your back pocket when it comes time. Maybe you're in year 3 and you're not sure if you're going to get selected or not. Register in the lottery and file the O1. Just do them both and see which one can work. But start working on that. You should be working on building up your O1 resume when you are finishing college, not the third year where you're in your last year of STEM OPT.
Okay. Well, thank you so much, Justin and Yash. I hope that was very helpful. Thank you for participating. Let's take up our next one. This is from Sneha. Sneha is asking, will the potential changes in wage levels for H1B applications make it more expensive for companies to hire Indian workers? And how should we prepare for this impact?
I mean, you're going to have to see if that's an actual implemented policy where the wage levels are moved up. This has been something that's been toyed around with last time Trump was in power, and now it's probably going to be rehashed. The easiest way to make the H-1B program less appealing is to make it harder to qualify for an H-1B and make it harder for a company to pay someone an H-1B. I think at the end of the day, if you raise wages, the people who are weeded out are the smaller organizations. Bigger companies aren't going to really care if they got to pay somebody $20,000, $30,000, or $40,000 more dollars. It's not hurting their bottom line. The people that care are the 25 and under employee companies, where that's a big thing. a big decision to make, whether or not you're going to pay this guy $40K more, or maybe pay a less qualified person who you don't have to sponsor. And so that's kind of what becomes the issue. I think when it gets to that point, you're going to have to really start looking at what are the benefits that can be provided. I know that there are certain, and I'm not a tax lawyer, so please don't, pretend I know these things. I know there are certain tax breaks that people can get for someone that's on an H-1B if they've only been in the United States for a set number of years. Look into those policies, see if that's something you can present to your employer as a way to recoup fees, if there is an increase in the amount of money that has to be paid. That being said, there's not really a great workaround because the wages are set if the wages are set. So if you got to pay someone X amount to be a software developer in Austin, Texas, that's what you have to pay them. If they're a level 2, you pay level 2, level 3, etc. But we'll kind of see what happens with that. I can't imagine that a business-oriented individual who has the ear of the president, that would be, Elon and Vivek. I can't imagine those individuals would seek to make companies pay more money for employees. So we'll see. But yeah, that would be it. I would just say you're gonna have to find workarounds to make yourself look more appealing in that circumstance.
Right. But thank you so much for taking that up, and thank you, Sneha, for participating with your comment on YouTube. So we'll take a couple more questions quickly, and Control, if you can display them, please. So this first one is my initial H-1B was expiring on September 30th. Employer put in an extension for a few days before under premium processing. I received an RFE for maintenance of status since I got laid off by the end client, and my employer did not run payroll for 2 months. Now the employer told me they respond to the RFE. The deadline is 10th January. What are my options now? I'm really worried. Can I convert to B1 or F1 visa?
So not real. I would say a couple of things. First off, I would say you should report your employer to the DOL, because if you are still in the U.S. working subject to an H-1B with the employer and they're not running your payroll, that's a violation. I don't know if they're I don't know if they're operating under the guise that because the extension's not approved, they don't have to pay you. But at the end of the day, USCIS views maintenance of status pretty solely through the prism of, are you getting paid by your H-1B employer, and are you working where the LCA says to work? If you're not getting paid by your employer, you can't show maintenance of status. Yeah, I mean, it's very difficult for you to attempt to file a change of status to another status right now, because you're going to run into the exact same problem. At the time of filing, how are you maintaining status? If you couldn't show that at the time you were filing your extension, you can't show that now. So I would probably say, post a bag. Period of stay authorized by the Attorney General allows you to remain in the United States up until it's denied. If the only issue on your case was maintenance of status, they should approve your H-1B but deny the I-94, deny the extension. So what that means is you should have an H-1B that you could subsequently utilize if you still have an active visa, or if you have to go abroad to get a new H-1B visa stamp, you could do that as well. A problem, though, with all of this is if your employer's not paying you, I'm not really sure how you're employed with them. So even if your H-1B gets approved for consular processing, the denial of the maintenance of status goes into your immigration record, and it's going to be available at the consulate. It's going to have to be something that you can explain. So you're going to need some sort of new support letter from your employer explaining that they intend to bring you back. That all being said, I don't really know what the employer put in your RFE response that was due on January 10th. So we would kind of have to wait and see there too. So I would say this: you need to see what the decision is and abide by the decision. The decision is denial without the H-1 being approved. You need to timely depart the United States and apply for a new visa abroad. If it's an approval of the H-1B, exit and take whatever steps are necessary to reactivate your H-1B to come in, and then you're going to have to work with your employer on that. But I would not really recommend filing an attempted change of status at this point to a B1 because it's just you don't have the ability to prove that you're maintaining status.
Right, right. Thank you so much, Justin, for taking that up. And all you folks out there, thank you so much for tuning in today. And a big thank you to you, Attorney Justin Rivera, for sharing your expertise today with us.
Thank you. Before we go, because I saw there was a couple of questions about F1. Oh, apparently I won't be allowed to. My connection is lost. Well, if you guys can hear.
Yes, we can.
Let me see if you guys can.
We
Yes,
can hear
sir.
you.
Yes, sir. We can hear you, sir. No problem. Go ahead.
Nope. Again.
Oh, good. Sir, we can hear you.
All right. So I would just say thank you so much, all you folks, for
Right.
joining us. And
Right.
yeah, Justin, if you can just wrap up what you have to say before we leave.
Real quick, just a quick thing about F1. People who are looking at F1 status. OPT, initial ownership, not on STEM OPT. So no one should be taking unpaid internships on STEM OPT. I've seen a recent uptick in RFEs on that. OPT, you can take an unpaid internship. I have seen 2 decisions now, not my cases, for other people, where USCIS has denied STEM OPT, saying that the OPT employment, the unpaid internship, should have been paid. And they're using an interesting justification to do that. They're basically looking at employment law and basically saying they're kind of making up what can and can't be an unpaid internship, which is kind of crazy, but it's denials for these people. These people that are going for STEM extensions, their STEM is done. So they're in a bad spot now because they're now not able to get that extra 2 years. So what I mean by all that is this: everyone moving forward, be careful with working on an unpaid internship while you are on F1. I would recommend staying with paid if absolutely possible. If unpaid, work with your school to make sure that it's going to fall within regulatory requirements.
Okay.
And that being said, I am done. Thank you all very much for your time.
Thank you so much, Justin. Really, we had some great updates, and we're really lucky that you could share them with us today. So, really, a big thank you to you, Attorney Justin Rivera from Wasden Immigration Litigation. I'm really looking forward for our next episode already. So, thank you once again. You have a great day ahead.
Absolutely. Thank you. Pleasure speaking with you guys. Y'all have a good one.
Thank you. Thank you, Justin.
Bye.
So, folks, don't forget to like, share, and subscribe if you resonated with today's episode and you liked our insightful webinar with Attorney Justin Rivera. And yes, thank you so much for tuning in today. Don't forget to also hit the bell icon. Uh, we are Immigration and Jobs Talk Show, and we are on YouTube, LinkedIn, Facebook, and on X as well. So please feel free to connect with us. And you can also email me, and my email address is neep@staffingme.com. And yes, connect with Attorney Justin Rivera. You can call him up on his number, and his phone number is 844-592-7336. And you can email him at support@wasden.law, and go visit www.wasden.law to get to know more about Wasden Immigration Litigation and Attorney Justin Rivera. Once again, thank you, folks, and stay tuned on Immigration and Jobs Talk Show, because I and Sam are going to come with a daily immigration dose at 4 p.m. Eastern Time. So until then, you guys keep having a great time ahead.